I'm attorney Nick Alcock, and if you found yourself in the RCC and you've been charged with a felony case in Maricopa County and you're at the Regional Court Center and you're facing this court date, you want to know, okay, what's going to happen to me? What you need to know is that that first court appearance in RCC is not a trial. Realistically, the RCC was put together to expedite cases, to enable prosecutors to make plea offers, have public defenders all in the same building, all on the same floor, and try to churn cases and move them through. This is great for the system. It probably saves the county a lot of money because the county is paying the salaries for both the public defenders and the county attorney's office. And I'm not disparaging the public defender's office at all. They have a lot of hardworking attorneys and they're good, but this is a cost-saving type of idea. And the idea is get everybody together before the case is set to some type of trial setting, before it goes to trial court. Put them all in the same area and see if you can work out a negotiated settlement. Now, there are some pitfalls and there are some things that you need to be aware of if you have a felony case and you're going to the RCC. First of all, when you're meeting with your public defender or when you're meeting with your attorney for the first time, many times they're not going to know all of the ins and outs of your case. They're not going to know what witnesses are going to say. They maybe have not read all of the discovery. And so the system is designed to put the prosecutor and defense attorney together to negotiate a case when that defense attorney may not really know anything about your case. And so it really puts people in a tough situation where they have to decide whether or not to take a plea agreement. And taking a plea agreement without knowing all the facts of the case is sort of a risky proposition. Also, there might be motions that could be filed. There might be something about the case where there is a procedural or constitutional violation. Your attorney has the ability to file a motion to suppress, a motion to dismiss, but can't file it at the RCC level. Because if they file it there, then they're not going to hear it. It has to go to the trial group. But in order to exercise that right, you might lose a plea agreement. So you may have a case where you've got a real clear, but it's a bad stop motion. The police pulled you over for no reason. There's no reasonable suspicion to effectuate that traffic stop. So you got this really good motion, but they made a really good plea, and the plea is going to go away if you try to litigate that motion. So you don't have all of your rights at the RCC ready and available to you. You can't litigate the case. You're not in the trial group. So that's a bit of a pitfall. Now, one of the advantages is that every once in a while you get a sweetheart deal because, as I said, they want to have those cases move. They don't want all these cases go to the trial group. So every once in a while you come across a situation where they are making legitimately a very, very good offer. If, however, they're making an offer which is not particularly good, then of course, our advice would be that you should, exercise your right, go to trial, set it up to trial group. It's awfully hard to know sometimes because, again, you're operating in the dark and in the blind. You don't have access to all of the evidence. You can't do some of the discovery. You can't do some of those interviews that are so important to really establish how much evidence is against you. So, in order to survive this, I really invite you to get second opinions before you take a plea agreement. Normally at the RCC, if a plea offer is made, they're going to give you 30 days. They're going to give you a couple weeks to consider your options. And so if you have that plea, there's nothing wrong with taking a copy of the plea, getting a copy of your police reports, calling an attorney, getting a second or third opinion. Because you need to know whether or not this plea offer is a favorable plea offer for you or one which is run-of-the-mill. You also need to know what are the risks if you take this case to trial group. Are you really going to lose this plea agreement? Sometimes the prosecutors will say, look, this is it. It's a fast track case. This is the plea that we're going to make. If he doesn't take the plea agreement, then we're going to set his matter to trial, and there will be no plea agreement in the future. That can be known. Conversations can be had with the prosecutor to determine just how fragile that plea agreement is and whether or not it will be extended in the future. So if you're at the RCC, they made a plea agreement to, you don't really know whether or not you should do it. Get a copy of your police report because that should be made available to you. Get a copy of the plea. You can always call 602-989-5000. That's 602-989-5000. We're happy to sit down and speak with you and go through your case and look for avenues, look for paths to get you to the right outcome that you deserve. Again, 602-989-5000. My name is Nick Alcock. We're here to help you. Any case in Arizona, federal, misdemeanor, felony, Superior Court, doesn't matter. We're licensed in all those courts. We're here to help you. Thanks so much for watching. Really appreciate it.